I gotta do a law school question, okay? Yeah. Here's a law school question, okay? So you have a trial, and part of the prosecution case is they have either an audio or video recording with audio, and it's a discussion where the accused is saying certain things,
right?
But it's hard to understand.
Bit of an accent, hard to understand.
Bit of an accent.
Yeah.
English is not the first language. Person may be a bit confused as to how to articulate themselves. So it becomes this pivotal piece of evidence at trial, and you hear it, there's cross-examination on it, and then, well, first of all, there's testimony about it, and there's cross-examination by the Crown, and then at the end of the day, during submissions, you have some dialogue as to what is actually stated on the audio recording or the video recording, and then submissions are done.
Right.
Judge goes away and reserves their decision.
Right.
During that time, the judge then watches or listens to the actual audio or video recording, comes to a completely different conclusion than what was agreed upon during submissions.
In court, yep.
And the accused and Crown, frankly, doesn't find out about this different position taken by the judge until the conviction is rendered through the ruling. Okay, have I laid this out enough?
Yeah, it sounds like a good exam question.
In submissions, the judge sort of indicates, I understand that the accused during this recording had said cup.
Right.
And then comes back in the ruling says assault.
Right.
I heard him say assault.
Right.
Okay? Assaulted.
Right.
Okay? Is there something wrong with that? I'm just curious because it's something that, maybe it's a complex legal issue.
Maybe.
I don't know.
So closing submissions.
Over to you, Diana.
Because a lot of people don't understand the point of closing submissions, and that's to summarize the evidence for the trial judge. And then there's some discussion about the summaries and whether people agree with the summaries. So it's clear what the evidence is that's there to be before the court to be considered. And if a judge goes off and comes to conclusions
Can I just
about
have a short
evidence,
answer on my law school question? Yeah. Is there something wrong with that, Michael?
Yes, I was deprived of making submissions on that issue, Your Honor.
Correct.
I passed, yes.
It is an error of law, a really bad error of law. If you make a finding on your own after listening or watching a piece of evidence without then re-engaging counsel for submissions on that particular issue that you have now determined in your head, you've got a problem. That's an error of law.
That's a big problem.
And
go ahead, Dee.
The Ontario Court of Appeal would agree with you.
Yes. You've been dying to say the case, haven't you?
In the case that's RVPP 2025 ONCA 243.
It's going to be like a Bart Simpson thing. You've been dying to say PP all night.
Set up the facts.
Every time we talked about it, it was like, the PP case.
Oh, my God.
Okay, we'll behave
set up
now.
the facts, and then I just want to talk about the fundamental principle here, because this is something I would expect that we'd all understand by this point. Mm-hmm. But let's just
So there were three main errors that were discussed. There were more concerning issues, but they only focused on three of the main ones.
Three biggies.
And the first one I found really interesting because it's a situation that we have quite a few clients in this situation,
right,
where they end up before the courts after engaging in an arranged marriage. Mm-hmm. And in this case, the trial judge had disbelieved the accused that when they finally lived together, because there was a marriage and then a year and a half waiting for sponsorship and so on, and said beginning of the relationship living together they were quite happy. And she's like, this is
surreal
sounding.
Surreal.
Just read it.
That's the actual thing.
Paragraph 10.
Read it.
By way of example, the trial judge said the appellant's evidence that the two were happy in the beginning.
Speak slow.
His evidence that the two were happy in the beginning sounded surreal because they were basic strangers who had just moved in together, and this left aside the fact that they had been communicating with each other frequently over the entire time they were apart.
Making arrangements.
She, concluded that they were basically strangers to each other, which was an accurate summary.
How could they possibly be happy?
So this was called a sweeping generalization about human conduct. But this is concerning because, the complainant in this case, as we've seen in many others, makes out this case that the marriage was arranged, and thus the male in the relationship was very controlling and manipulating and abusive,
which we see often,
very often
in cultural stereotypes, particularly where you're dealing with arranged marriages. That tends to be the mantra which is used by a complainant to say he was the typical X, Y, or Z. And was controlling and abusive, and I didn't have control of the finances, I didn't have this, I didn't have that.
That's right.
Ripe for abuse. Cultural stereotypes.
And the court says trial judges are entitled to make common sense assumptions, but they are not entitled to engage in sweeping generalizations about human conduct. And that's what she did here.
That's ungrounded.
Yeah. Arranged marriage, therefore, there's no way they could be happy.
No, how could that be different, though? How could that be grounded in the evidence? If you were to, have some agreement at trial between the two of them that that when they first moved in together, they felt like they didn't really know each other very well.
Easy. You can have a complainant testify to say, we didn't know each other, we communicated very little prior to being married.
Our parents arranged all of this.
We had little to no interaction. I wound up really just meeting him at the time of marriage. And even through the accused evidence, through cross-examination by the Crown Attorney, can establish that there was little to no basis for them to have any commonality or understanding of each other. Therefore, you're starting to create a foundation to maybe draw the inference that they were essentially strangers at the time of marriage. But even then, it's not something that would be beyond belief that two people who don't know each other but come together with a cultural normality
could be happy.
Could, through the first several months, enjoy each other's company and be happy.
Imagine. And we did have 1.5 years in there, and there's a lot of people who end up in really good relationships who meet online and don't even meet each other
for ages,
for a long, long time.
And with due respect, having worked in Toronto for over 32 years, where we have acted for a diversity of clients,
multicultural,
many of which who have been in arranged marriages, and people I know who've been in arranged marriages have said, it's actually been quite delightful. Because they come from families that know each other, cultural and familiar similarities, belief systems that are similar, and therefore they have a basis of
attraction,
but commonality that roots them in their relationship.
And there's still a choice. It's not like you're just told you have to marry this person or else. You know what I mean? They meet.
We've seen
not always, but
They meet and they spend time together in the company of family and stuff, and then they make decisions about whether or not they want to go forward with it. Like
not always.
Majority of times.
Not always. But I want to just emphasize that it is very arrogant of us from a Canadian-centric approach to say that two people who just meet each other and get married can't actually be happy together, because I have actually known couples who did engage that way, but because of the families knowing each other, because of the cultural similarities, because of the underpinnings of their belief systems, that they matched and actually built a strong partnership.
So we have like the second error that they found, legal error, which I'll let you describe, and is very close to the scenario that Joseph set up earlier.
Which one? The Freudian slip?
The Freudian slip. This was the phrase the judge said there were.
I think there's two Freudian slips.
Yeah, there's two.
In this one.
There's two. I think we've covered the one. This is the slept versus slapped, right?
Right.
Yeah, let's just cover it though with the case, because I just want to read the fundamental principle.
Right. So in this particular case, in responding to a question during his examination in chief, Crown Counsel thought the appellant had said in relation to a particular incident that he had slapped the complainant. In cross-examination, when this was put to the appellant, he denied that. In fact, said he had slept after the incident. So this led to a disagreement amongst everyone in terms of what did he say. So the proceedings were interrupted so that the digital recordings of the evidence could be played back in court. But before the recording was played back, the judge said, I don't recall him saying slapped. Defense counsel said, no, he said slapped. And after the recording was played, the Crown still was of the view that he had said slapped. But the Crown said, okay, I'm prepared to accept that he may have corrected himself and said slept.
Just to be clear, we're talking about going to sleep.
Yeah.
Slept.
Crown conceded, it's English was not his first language, so he may have meant slept. So that's how the issue was left at that point.
The issue was left at that. No further mention was made of it, and no submissions were made at the conclusion of trial about it.
Because everybody agreed.
Right. So, however, in the reasons of the trial judge said that they listened to the digital recording while writing reasons, and said now that they agreed with the Crown Counsel that the appellant had said slapped. The trial judge then characterized this as a Freudian slip that she relied on as undermining the credibility of the appellant. This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record, and now back to our podcast. Thank you. On appeal, the court noted, this was improper for the trial judge to treat this evidence as she did for two reasons. First, she did not indicate at the time that the issue arose that she had heard the appellant say slapped. Indeed, as noted above, she said the opposite. The only person who had the view that the accused said slapped was Crown Counsel, and he eventually agreed that the accused had corrected it to slept.
Right.
Second, for some reason, the trial judge decided to revisit the issue while the case was under reserve, meaning at the time that they're writing their reasons, and then changed their mind about what was said. She had an obligation to advise counsel of the fact and permit them to make submissions on the issue before relying on it as a basis for disbelieving the appellant.
Right.
It is a fundamental principle of criminal law that an accused person has the right to know the case that they must meet, to know the evidence that is to be used against them. This point is made in various cases. I won't go into it.
Right.
It goes back in time perpetuity. It is a hallmark of the criminal law process. You must know the case that you have to meet.
Imagine that.
So, they gave an example of something that could have happened, which is the judge could have advised counsel, the Crown and the defense counsel, that there was a question that came up during the deliberations as she was reserving, and then had further questions and could have put that to
Totally
you.
happened. I've had that happen.
I've had that happen, yeah.
Totally. Trial judge is reviewing everything and then thinks, oh my gosh, here's an issue. Wrote to us. Brought us back for submissions. Excellent. That's
how you do it.
Perfectly
They
fine.
think of something that and they have to consider whether or not, and that's one of the things that happens during closing submissions, is the judge has an opportunity to pose questions to both counsel to get their feedback on issues.
Even after closing submissions, like
And
Joe
afterwards.
said, if they come
Yeah, it's
across
not over.
something,
The case isn't over.
not over till
it's
there's a
not over
finding.
until somebody's sentenced. Let's be clear about this.
right?
Trial cases are not over until the person is sentenced. Until
Or
then,
acquitted.
I just want to say it goes all the way along. So you can reopen a case at any point up until the end of sentencing. Okay? So in this case, the trial judge did not honor the principle that in handling this evidence, the trial judge placed significance on the evidence that it did not properly bear. In the eyes of the trial judge, it became an equivalent of an admission by the appellant of an assault. The conclusion would have inevitably led the trial judge to reject the rest of the appellant's evidence as she did. It was pivotal, it was central, it was significant. It is a basic principle of law. You have to invite submissions on that. There's nothing wrong with thinking about it and going, oh gosh, now that I listen to this over and over, I think this is what I'm hearing. I got to address this with Crown and defense. No problem.
And it's a pivotal kind of word to mishear as well.
yeah. And
The difference, the difference between saying I slapped somebody, which would be an admission of of a crime, versus I fell asleep, I slept.
Yeah.
And those two words, even listening to you say them, they're very, very similar.
They are.
And but
add on a layer of accent because it's not your first language. Yeah.
the fundamental principle that you mentioned, it really stood out to me in this case, though, is the importance of knowing the case to meet. We could probably expand on that a little bit, because I think there's a little bit more just in terms of the process to understand that's one of the reasons that the Crown must call all of their evidence before the defense calls their evidence, is your right to know the case to be met.
Right.
And so, it's also one of the reasons we have disclosure requirements, where the Crown can't hold on to evidence and then surprise you with it later.
Right.
That you have to, when you're the accused and you're kind of the underdog going against the power of the state, you have a right to know what their case is, and it's the obligation on the Crown to prove their case. So when you end up with a judge who then alters evidence after all the submissions are made,
Not altering the evidence.
in her mind,
No, not altering. The judge is not altering the evidence. The judge is coming to a different conclusion about what the testimony means.
Right.
Okay? Yeah. And that's fine. No problem. But you must alert the Crown and defense to now coming to a different conclusion and invite submissions upon that.
Right.
So that there is a fair approach taken, so the accused, again, is aware of this issue, knowing the case that they have to meet. There is nothing wrong during the course of writing out the reasons and reviewing evidence. There's nothing wrong with that, and arriving at a different conclusion. But then you must alert everybody and invite submissions on the point. That is the basic concept. And that, combined with, in this case, what the Court of Appeal noted, was that there was a cumulative effect of ungrounded assumptions and a failure to avert to this very basic principle of criminal law that made this case untenable and had to be overturned.
But wait, there's more.
I know, I'm kind of
I
ahead.
was just saying altered because originally they said she ended up saying the opposite of what she said during the trial.
Yeah, but I don't want to mislead.
But you're right.
It's not altered. She didn't alter it. To be fair to her, she's just listening to. We've all had cases where we're wiretap evidence. In particular, it's very difficult for a judge when you're hearing evidence, and sometimes where it's a lot of audio recorded evidence, and you don't have the benefit of an accurate transcript of it. One can be forgiven to have to go back and listen and go, okay, I'm hearing something different now. You just alert everybody to it. Right. Mm-hmm. And to me, it's just like, it's just, this is a basic. Right. But anyways, go ahead. What's the other issue?
Diana? You wanted this one. The COVID. The funny COVID.
So this was kind of a minor thing, but still it was
Still added
wasn't
up.
that minor.
It
wasn't that minor.
It was a reason. It was a reason to disbelieve his evidence as a whole.
Right.
It lent into that. All of these things combined together. But one of the things that the accused said was he was accused of uttering a threat against his partner, and he said, "No. That day, I drove them to a COVID vaccination."
Right.
And then he had another appointment for himself
for his own COVID
and said
shot,
when he dropped them off, he immediately left because he thought there was going to be a big lineup and wanted to make sure he was there on time.
So he wanted to be much earlier.
And so he went an hour earlier. And the judge specifically disbelieved this and took judicial notice that when you went to get the vaccines, there was an advisement to not show up more than 10 or 15 minutes before the vaccine. Because, of course, they're trying to keep people from gathering in large groups. But because that was the notice on your information that you got about your appointment, that she specifically decided that nobody was showing up more than 10 to 15 minutes earlier.
Right.
And so they said that even if you accepted that there could be some judicial notice taken,
you could say that was certainly the recommendation.
That was the practice, perhaps.
Even if you recognize that,
like keeping 6 feet apart.
Right.
It doesn't inform the trial judge of the actual practice that people are engaged in surrounding obtaining their vaccines. So this was an assumption that everybody did precisely what they were told and followed everything to a T. And therefore, this accused person was unbelievable because...
Right.
Can I just say, remember Partygate in the UK?
Right.
Okay, that basically unseated the Prime Minister in Great Britain because although they were making recommendations, there were government policy about what to do and what not to do during COVID. They're having birthday parties, which I don't fucking blame them for anyways, because I think all this social distancing, et cetera, was a little excessive in it. But to then make a conclusion based upon a government recommendation or Shoppers Drug Mart's recommendation as to when to turn up for your COVID vaccine?
Yeah, that's a bit much. Like the court said, there was no basis for the trial judge to reject the appellant's evidence on the basis of what the provincial government had advised people to do without any evidence as to what people were actually doing. There was none. It was just what he said. Yeah.
So, and then you had pointed this out earlier too, as like one of the important things they put in here is that, in the end, the reasons given by the judge have to explain why the conviction was made and why it was safe. And they say, an accused person should not be left.
Shepherd, yeah.
Yeah, quoting from Shepherd, an accused person should not be left in doubt about why a conviction has been entered.
Right.
So that's one of the important things on appeals. This case, there were lots of reasons given. Sometimes we'll have cases where there's like hardly any reasons.
Yeah, but there can be cases where a judge's reasons are not as fulsome as they should be, but because of the record before the Court of Appeal, there is so much evidence of which the judge could rely upon to ground a conviction in, for example, that it would hold.
Right.
So you can have a really robust record of evidence that would then support the judge's reasons. It doesn't necessarily mean, you have to have 40 pages of written reasons, but the accused needs to know why they were convicted.
Yeah.
And in this case, the Court of Appeal, interestingly, just summarized.
Yeah.
In this case, the trial judge relied on unsupported assumptions about how people involved in an arranged marriage would act, improperly relied upon evidentiary fact that was not established, on which counsel did not have an opportunity to make submissions, and improperly drew conclusions regarding the actions of people based on government COVID protocols for which there was no evidentiary foundation. Whether one characterized these errors as errors of law, as in the first example, or as a palpable and overriding errors of fact, as in the second and third examples, they render the convictions unsafe. And that's interesting because in Kruk, that's the Supreme Court of Canada case where they talked about what are ungrounded assumptions and whether it amounts to an error of law, which would not be reversible, or a palpable and overriding error, which then would be reversible. So Justice Nordheimer is saying, regardless, when you take all these into consideration, they rendered the conviction unsafe. Yeah. And therefore, the convictions were set aside and a new trial is ordered. And I think this is an extremely good caution about how you deal with ungrounded assumptions.
Yeah.
It's important, even though we can, because of Kruk, use common sense inferences about how humans behave. And I think that's really important that it's brought back, that common sense is brought back. We have to be careful not to expand that too much, to go into so many other areas where really the trier of fact does not have that base of knowledge to make these assumptions, and it's not grounded in the record before the judge.
Right. That's important.
So, this was a case of an appeal, and, at the point of an appeal, you're not in trial anymore and you just have to redo the whole thing again. So, then to me, the question is, what can we get from this, in terms of people going to trial? What would be the
Written submissions.
Written submissions?
Yeah.
But I think also it gives such an interesting array of,
mistakes,
of flaws of logic, and ungrounded assumptions that I think it's a really good reminder for people going to trial to think about how they present their scenarios and their evidence, and think about how many misunderstandings could occur, and just to try and be more vigilant to address it. And I guess, it's that dialogue between the judge and defense and Crown is so important.
This is why in 98% of the cases we do, judge alone, we are doing very detailed written submissions, because we know judges are under pressure. Judges have reasons to write. They have a lot of reasons to write. It's not an easy job. And so if we can give very detailed written reasons on facts, on the law, and how to apply that law to the facts, it will help the judges do their job. Right. And we can deal with ahead of time what may be unreasonable reliance upon ungrounded assumptions or discriminatory beliefs or misuse of evidence, and make it crystal clear what evidence we all agree on. And I think this is a good pointer for the fact that if you don't have time for written submissions as counsel, make sure you have a fairly good script of what you're going to say orally and hammer it home. Because you have to understand, a judge, when they go back to write their reasons, are doing the best they can from their written notes of what was said. Right. And that's not easy too. No. So I have sympathy. It's very easy for us to criticize a trial judge, but it's difficult. They're hearing trial after trial after trial. Right. The Ontario Court of Justice does 86% of the work, and they're under tremendous pressure in some of these jurisdictions which are overwhelmed, and so they need as much help as possible from counsel. So good work means providing detailed submissions, whether you do it orally and take your time that you know that the judge is able to make the notes. Pay attention to the judge because they're typing or they're writing. And if you can, even if it's in point form, do written submissions of some kind.
Right.
And we have, a growing collection of cases that are really helpful for reference too, because it's always discussed in our submissions about myths and stereotypes and the use of common sense and so on, and so this can get added to it. But you see unusual assumptions, like because some people may befriend, in one case that we reference a lot, one person might be really nice to somebody in order to to lure them into a situation where they can be taken advantage of. You can't then assume that just because somebody's nice, it makes them a predator.
Yeah.
Right.
And so, you see lots of things like that come up, and it's just, it's an interesting case to look at, I think, and just to keep in mind.
The only thing is, I just want to remind everybody to be careful with sort of basic principles. It may be, I don't want to be harsh. It may just be a momentary error that they'll never repeat again. But we've got to remind ourselves about basic principles of law. Whether we're Crown attorneys, defense lawyers, or judges, that there are certain things that you need to engage everybody on. And we shouldn't make these mistakes because it results in appeals and retrials, which are very traumatic, both for complainants and for accused.
And expensive.
Right. And I'm adding that into trauma. Financial trauma exists, right? You can imagine access to justice and how difficult this is.
And it's hard on the system. It clogs the system.
Right. Yeah, in some jurisdictions, Toronto's done a great job of dealing with the backlog. In other jurisdictions, they're just overwhelmed because of the sheer population and the percentage of offenses. So we need to help each other to get this right. And I think, sort of a more palatable way of saying this is we really do need to help each other when we get it right. And some of the cases that we have that we've enjoyed so much is where we are working with the Crown attorney and they're putting in good written submissions. We've exchanged it. And we're trying to be very fair on the evidence. And often we've seen, I agree with defense counsel on this, I agree with Crown counsel on this, and we have a very good dialogue with the judge just to make sure we're at edem about what is at issue and what isn't.
Right.
And I think that will make the system work much more smoothly so we can arrive at truthful or just results.
Right.
Of course, what we determine to be just, others will say is not, but we feel fairly confident, again, about those cases because we have a particular type of clientele and we believe in it. Very strongly. So Pillow Talk, thank you very much for all your viewership, your comments. Again, we watch very carefully the comments when our podcast drops. We interact with it. And then, the comments that we're getting from the clips that we put up, etc., are very, very helpful. So please, if you like what we say, like, share, subscribe, and
share and hit notifications.
Hit notifications. And just keep engaging with us because it's so incredibly helpful and we really enjoy it. So thank you very much and good night.
Thank you.